So the Supreme Court has ruled today that the Medical Termination of Pregnancy Act, which when it was came in 1971, it was essentially for married women. But today the times have evolved. The act has been amended, and it is now available for all women. All women, without comparison to their marital status, are to be treated equally. What is important to note is the court has taken into account teenagers' cases, because we see that there are POCSO mandates where if a teenager is involved in a consensual relationship and if they say want to terminate a pregnancy, one of the parties is bound to will have to report under POCSO. Then there's an issue of mental health which has been accounted for, which is very, very important. And from mental health also abusive marriages, which is, you see, the issue of marital rape is grey law. The law is really unclear on it as of today. But the court goes ahead and says that from an abusive marriage, a woman may not want to bear a child, and it is for her to decide if she wants to continue with this pregnancy or not. So for women especially, I mean, the most notable part of this judgment today is that this is entirely right-based. They've given you a rights perspective rather than administrative or a medical perspective, which we've been working with so far.
What will be the impact of this judgment, ma'am, right now?
The impact is primarily, first and foremost, for unmarried women, because so far the act was being read so as to cater only to married women. But you see, in our society today, we have, as the court says, non-traditional familial relations. You have live-in, you have single women, you have same-sex couples, you have all kinds of equations that are being now given sanctity of the society. Whether or not they require sanctity of society is a different issue, but they are today being accepted. And these are relations that will now have the services that MTP Act intended to provide at their disposal.
Remarkable in itself, as it removed the discrimination between married and unmarried. Today, all the women are at the same pedestal, at the same footing, and there is no discrimination between them now. If any woman wants to terminate their pregnancy up to 20 weeks, without their discrimination, they can go. Not only this, if any unmarried woman also wants to terminate their pregnancy up to 24 weeks, without any spousal consent, without any restrictions, she can go. No one will question why you are going to terminate. Earlier, there is a rule in 2021 which was made, and that was confined only to married women. That married women can terminate up to their pregnancy up to 24 weeks only for certain category of women. Rule 3B, Rule 3C. Just like I give you example for that, like divorcee, widow, rape victims, disabled, mentally retarded. The termination of pregnancy right was given to these category of women because they were vulnerable. The unmarried woman was excluded from this category. So this petitioner came to me who was having 24 weeks pregnancy out of consensual relationship, out of live-in relationship, but she was denied her right of termination from the Delhi High Court. After that, the Honorable Supreme Court held that this is her reproductive right, personal autonomy, bodily integrity. So she should not be denied from her fundamental right under Article 21 of the Constitution of India. Therefore, today's judgment has removed that discrimination between married and unmarried, and this judgment will be applicable, will set benchmarks not only for India, rather all over the world.